Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Welcome. It is 19 February 2026 years after Jesus. It's a Thursday. And we're back in Baird versus Bonta. We stopped in on page 11, which is where we're going to pick up in Roman numeral II. This is the Ninth Circuit, the Republicans on the Ninth Circuit, affirming the right rooted in history and tradition, correctly applying the correct approach to the Second Amendment laid out in Bruin, 2022, by the Republicans on the Supreme Court. This episode is done again in honor of my cousin, Little Dan Mountain Jr. Little Dan, this is for you. We're continuing on. Baird is a resident of Siskiyou County, California, and a lawful firearm owner. For several years, the Ninth Circuit continues. Republicans on the Ninth Circuit. He has sought to lawfully open carry for self-defense throughout his home state. Seems like a pretty reasonable request. Page 12 at the top. We're going to have the link in the description, so you can just click on the link and follow along. But California has prevented him from doing so by criminalizing the open carry of a handgun in urban areas of the state, whether loaded or unloaded. Siskiyou County, where Baird lives, has a population of 42,498 as measured at the last census. So Baird is among the 5% of California's population living in a county where open carry is theoretically allowed, but only with an open carry license. And even then, only in his home county. What a bunch of bullcrap. Only in his home county. You live on the county line, and Ralph's or Trader Joe's is just on the other side of the county line. Does that ever happen? Yeah. Yeah, it does. It sure does. Can I give you an example? I live in Orange County. It's called Orange County because when you drive into the county, it's orange. Everything is orange. And so the founder of Orange County said, hey, check it out. Everything is orange. Let's call this Orange County. Yeah, that's funny. I know it's really funny, isn't it? Well, Brea on the northern part of Orange County is just a hop, skip, and a jump away from Diamond Bar, which is in LA County. Now, it turns out that Brea has a full assortment of, you know, places to get food. It's got a Trader Joe's, it's got Ralph's, it's got the Dollar Tree, which is where I go. It's got a Walmart, it's got a Home Depot, it's got Korean barbecue, very important. It's got a Mountain Mike's Pizza. I think it has a Starbucks. It's got a Taco Hell. If you search Taco Hell, all the Taco Bells come up. Can't make that up. It's got a Pepe's, which I highly recommend. It has the Brea Mall, which apparently used to have a gun store inside of it and a knife shop, the Knife Gallery. I have a record of that myself. I've got a little price tag on the Knife Gallery from Brea Mall, one of my knives that I bought from the Knife Gallery in Orange. They're closed now, sadly. Um, but but there are situations in rural areas, which is the point here, where you could go across the county line to the nearest grocery store and become a criminal. This makes no sense. Baird is among the 5% of California's population living in a county where open carry is theoretically allowed, but only with an open carry license, and even then, only in his home county. What sense does that make? Especially if the theory is you can do it in a rural area, and the next county is rural, just as rural as your county, which is that's how it works in a lot of these rural areas. They're contiguous. Baird alleges that he has tried on multiple occasions to apply for an open carry license in Siskiyou County, but he has been candidly advised by the licensing authority in his county that no open carry licenses will be issued. This is ridiculous. In 2019, Baird filed a complaint against the California Attorney General challenging California's prohibition on the open carry of firearms under the Second, Fourth, and 14th Amendments. After the Supreme Court announced the proper standard for evaluating Second Amendment claims in Bruin, Baird filed a motion for preliminary injunction along with a second amended complaint. In this operative complaint, Baird maintains his challenge to the urban open carry ban. This is very important, found in the California Penal Code. Thus, although California attempts to frame Baird's, this is very important, listen to this. Thus, although Democrat California, that's the defendant here, the civil rights violators, the constitutional right violators, attempts to frame Baird's claim as only challenging a licensing requirement. That characterization is inapt. Baird is challenging California's regime that bans him from open carrying in the areas of the state where 95% of the people live, and no license is available in California. No license available in California can avoid that ban. Baird also challenges California's imposition of licensing requirements for the 5% of the state's population who live in counties with populations less than 200,000. Page 13 at the top. We're in Baird versus Bonta. This is January 2nd, 2025, right? Oh, sorry, 2026. My bad. In his opening brief before the court, Baird characterizes the question presented broadly as whether California Penal Code, blah, 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 which criminalize the open carry of handguns for self-defense, violate the Second Amendment. In his reply brief, Baird has an entire argument heading, "No tradition of open carry ban." And his attorney at this panel's first oral argument repeated the same point. There is an open carry ban in California. There's a citation there. The district court likewise recognized that Baird contends it is unconstitutional for California to impose criminal liability on people who carry firearms in public, and understood his theory as an argument that California cannot constitutionally require people to conceal any firearms they carry in public. Nevertheless, despite Baird's narrowing of his complaint and requested relief, the district court denied his motion for preliminary injunction. The court reasoned that Baird had standing to contest the state law generally in a facial challenge, but concluded that he lacked standing to assert any as-applied challenges to local government officials' failure to approve open carry permit applications because he brought his case against the wrong defendant. Okay. The page 14 at the top, district court reached this conclusion on the grounds that Baird sued only the California Attorney General rather than any statutorily designated licensing authorities such as county officials, and thus Even a favorable decision would not redress his alleged injury. That's a requirement for standing. Article 3 standing. You got to have a redress. Uh, I think that makes sense to me. Let me know what you think in the comments. The district court then dismissed Baird's as applied challenge to California's licensing regime. Now, listen to this though. As to Baird's surviving facial claims, the court denied the requested injunction without, I'm going to highlight this for you, without assessing his likelihood of success on the merits. Hmm. That's what I have in my notes here. Hmm. Hmm. I got a lot of hmms. Yeah, that sounds like clear error to me. Yeah, the district court requested injunction. Sorry, the district court denied the requested injunction without assessing his likelihood of success on the merits because Baird had not shown the balance of harm and public interest favors a preliminary injunction. This court reversed. That was back in 2023. Our decision was narrow, focusing on the district court's denial of Baird's motion for a preliminary injunction. We concluded that the district court abused its discretion. Yep, that's right. There you go. That's clear error. We concluded that the district court abused its discretion when it deliberately skipped any analysis of Baird's likelihood of success on the merits, because the likelihood of success factor can sharply tilt the court's assessment of other preliminary injunction factors. We thus remanded the case to the district court, ordering the district judge to apply the framework set forth in Bruin and expeditiously assess the merits of Baird's Second Amendment challenge. On remand, the district court addressed Baird's Second Amendment claims by bypassing Baird's request for a preliminary injunction and granting the government's motion for summary judgment. The Democrat government. The district court denied Baird's cross motion for summary judgment on the merits and denied Baird's motion for preliminary injunction as moot. The district court concluded that Baird's as-applied challenges to California's licensing regime remained dismissed because Baird had declined to amend his complaint to add any licensing officials or other local government defendants. With respect to Baird's facial challenge, the district court concluded that Baird's claims failed on the merits. We're on page 15 at the top. I'm going to get a drink of coffee. I'll be right back. Don't go anywhere. All right, got a nice cup of coffee going. I'm using this coffee mug that my grandpa gave me that Ray Cook gave to him. Ray Cook is a graduate of the U.S. Air Force Academy, and that's what this coffee mug says. Now, I didn't go to the Air Force Academy. I never even applied to it. I did get the congressional nomination to the Naval Academy. Didn't end up going. I ended up serving in a capacity that I wouldn't have been able to do if I had gone to the academy. I did special operations and intelligence right out of high school. And I got my degree while I was in active duty anyway. That was awesome. Praise the Lord. But Grandpa was a naval aviator, and he served during World War II, 1942 through, I think he separated in the reserves in the 1950s. I think Eisenhower was president at the time. But so they had some commonality, at least in terms of air issues. And this is a wonderful coffee mug that reminds me of my grandpa. even though it says U.S. Air Force Academy, and my grandpa was a Navy man, just like I am. Uh, TRP podcast guest Carrie Chavez teaches at the Air Force Academy. Her specialty is drones. Why am I going on about that? Well, look her episode up. It's very interesting. We're going to continue with Baird versus Bonta. And here we go. We're on page 15. Although the district court acknowledged that Baird's proposed conduct was presumptively protected under the Second Amendment, it ultimately concluded that California's urban open carry ban is consistent with the nation's historical tradition of firearm regulation. Excuse me. Pardon me. Don't know where that came from. Sorry. So Democrats are saying the open carry ban, the urban open carry ban, is consistent with the nation's historical tradition of firearm regulation. The district court first characterized California's regime as a mere licensing system, largely ignoring the reality that California's regime categorically bans open carry in the areas of the state where 95% of the people live and makes it challenging at best to acquire a license in those areas home to the remaining 5% of California's population where open carry could theoretically be lawful if one had a license. Notice how he put that theoretically. So he's making note here of the de facto situation. This language here, ignoring the reality. That's calling attention to the de facto situation. He tips his head to the theoretically lawful. So it might be de jure possible, but de facto it's not. It's kind of complicated to think about, but this happens. In this regard, the district court argued that states may require people to obtain licenses before they carry firearms in public, and there is a long historical tradition of jurisdictions imposing such requirements to make relevant distinctions concerning which people were not ordinary law-abiding citizens. The district court conducted a historical survey and concluded that American governments have imposed restrictions on how people carry guns since the founding era, and from that premise concluded that California's urban open carry ban does not offend the Second Amendment. The district court thus entered summary judgment in favor of Democrat California. I added the word Democrat. So Baird, pardon me, it's raining out, man. I may be getting a little bit of a cold. I don't normally get sick. I'm usually like strong as an ox, but Baird now appeals the district court's summary judgment order. He asked this court to restore to the citizens of California the right to carry a handgun open and exposed on one's person for self-defense. Page 16 at the top, and we're in Roman numeral III, and we're going to keep plowing ahead. This court reviews a district court's grant of summary judgment de novo. A grant of summary judgment is appropriate only when there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. We're in Roman numeral IV now. I'm going to take a drink of coffee. All right, so Roman numeral IV. We address Baird's facial and as applied challenges to California's urban open carry ban. If the Second Amendment's plain text covers an individual's conduct, that is an individual conduct that is proscribed by firearms regulation, then the Constitution presumptively protects that conduct. And the government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. That's quoting Bruin at 24. Also Rahimi at 691. In other words, the government must affirmatively prove that the challenge regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. It's on the government that has the burden of proof here. That's what Bruin clarified, that that is really what's going on here. The government has the burden of proof. So we're all waiting to see, what does the government say to supply that support. Regulations that extend beyond our historical tradition flout the Second Amendment's unqualified command that the right of the people to keep and bear arms shall not be infringed. That's Bruin at 32. This historical test often requires a searching inquiry, but not always. After all, many firearms regulations seek to address general societal problems that have persisted since the founding. In these instances, the inquiry is fairly straightforward. The absence of a distinctly similar historical regulation addressing the problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. Whether regulations are distinctly similar or relevantly similar turns on how and why the regulations burden a law-abiding citizen's right to armed self-defense. Likewise, if earlier generations addressed the societal problem but did so through materially different means, that too is evidence that a modern regulation is unconstitutional. On the other hand, cases that implicate unprecedented societal concerns or dramatic technological changes may require courts to take a closer look at how and why historical regulations burden a law-abiding citizen's right to armed self-defense. Stated differently, judicial review of regulations that were unimaginable at the founding will often involve reasoning by analogy, a commonplace task for any lawyer or judge. Well, that's definitely true. Stated differently, judicial review of regulations that were unimaginable at the founding will often involve reasoning by analogy, a commonplace task for any lawyers. We go over reasoning by analogy in all of my logic courses. This latter mode of analysis, the exception to Bruin's straightforward inquiry for regulations addressing a general societal problem that has persisted since the 18th century, is frequently referred to in this circuit as the nuanced approach. Excuse me. Under Bruin, many questions are straightforward, and when governments are attempting to address general societal problems that had persisted since the founding via regulations with no distinctly similar historical counterpart, then there is no need to consider the nuanced approach. And of course, it should be clear enough that courts may not turn straightforward cases into nuanced approach cases. Oh, this is so good right here. This is so good right here. Take a look at this. This is so good. Yeah. Yeah, see what the Democrats do is they like that nuanced approach language in Bruin. What they do is they fasten their teeth on that and they won't let go. They're like a dog with leftovers from Lucille's barbecue. And they don't read the rest of the opinion. They don't read that in context. They don't care. All they're doing is they're fastening on to something that lets them do what they want to do, which is to regulate the right out of existence because they care, because they're do-gooders and they care so much that they're willing to harm innocent people by criminalizing innocent conduct. So what he says here is this Republican judge, excuse me, sorry, got a little bit of a cold here. This Republican judge says on the bottom page 17, he says, of course, it should be clear enough that courts may not turn straightforward cases into nuanced approach cases. Page 18. See, he sees what they're doing. Now, these are straightforward cases. They're not nuanced approach cases. You want it to be a nuanced approach case because you think that gives you license to do whatever you want to do in the name of government and being good, doing good. But you can't turn straightforward cases into nuanced approach cases and then use the nuanced approach to ban the very things that were universally protected from the founding through Reconstruction, Republican Reconstruction. If that were allowed, then Bruin's instruction that the absence of a distinctly similar historical regulation addressing the problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment would have little practical force. There's a reductio ad absurdum argument. Although this court has recently confronted a panoply of Second Amendment cases, this case stands out in that it unquestionably involves a historical practice, open carry, that predates the ratification of the Bill of Rights in 1791. This case does not necessarily involve any new technology or any alleged social changes, right? The historical record makes unmistakably plain that open carry is a part of this nation's history and tradition. It was clearly protected at the time of the founding and at the time of the adoption of the 14th Amendment, the Republican 14th Amendment. We're going to take a look at footnote 14. Because the historical record is abundantly clear both at the time of the founding and at the time of the ratification of the 14th Amendment, we do not address the ongoing debate over whether evidences from 1791 or 1868 is more probative of the meaning of the right to bear arms made judicially enforceable against the states through the 14th Amendment. We're continuing on page 19 of Baird versus Bonta, January 2026, Ninth Circuit. Republicans on the Ninth Circuit enforcing the Constitution against Democrat California. Therefore, applying the Supreme Court's methodology in Bruin, this is a straightforward case that does not require a court to embark on the more difficult analogical journey under the quote nuanced approach, unquote. We begin with the founding. In 1789, despite there being a series of laws that regulated the discharge, storage, and aggressive use of firearms, there were no direct statutory bans on the carry of arms. Quoting the Yale Law Journal, 2014. This absence is particularly conspicuous because the founding generation was clearly aware of the dangers of gun violence, and states enacted a variety of regulations on addressing the lawful use of firearms. For example, a 1790 Ohio law prohibiting the firing of a gun within a quarter mile of any building or between sunset and sunrise. Yeah. Delaware likely, excuse me, Delaware likely prohibit. Wow, I screwed that up again. Delaware likewise prohibited the discharge of firearms in developed areas with an exception for days of public rejoicing. Wow. What could possibly go wrong? Yet, none of these laws banned open carry. Even more striking than that, some of these laws went out of their way to make clear that open carry would not be banned. Consider, for example, a founding era Pennsylvania law that prevented the use of firearms on public highways, but explicitly specified that the law barred only the discharge and not the open carry of those arms. Page 20 at the top. Excuse me. I have a little bit of a something going on. I'm fighting it. Don't worry. This argument is helping me stay strong. The historical record from the time of the 14th Amendment's adoption is, if anything, even more solicitous of the right to openly carry firearms. I mean, openly to carry firearms. Fixing the split infinitive there for you, Van Dyke, for self-defense. What is also striking about this time period is the clear difference in attitude toward bans on concealed carry, which were sometimes tolerated, and bans on open carry, which were not. Wow, this is very interesting. The general consensus at the time was that open carry was essential to protect the natural and common law right of self-defense, while those who relied on concealed weapons could not possibly be interested in self-defense, but instead must have an improper aggressive motive. Indeed, between 1822 and 1850, no fewer than six state high courts considered the scope of the right to carry firearms for self-defense and explicitly found constitutional significance in the distinction between open and concealed carry. And that significance manifested in broad constitutional protection for open carry, while the exigencies, jeez, and interests of public safety, there's that word. Democrats love that word. They think it they think it's basically a key to start any gun control car they want. That significance manifested in broad constitutional protection for open carry, while the exigencies, man, why can't I say that word today? Jeez. And interests of public safety were sometimes deemed to justify a ban on concealed carry. Sometimes. All right, well, um, for example, in State versus Reed, it's Alabama, 1840, Democrat Alabama, slave owning Alabama. Highest court ruled that concealed weapons ban was constitutional. See, Democrats. They're Democrats, but a ban on open carry would not be. According to the court, it is only when carried openly that weapons can be efficiently used for self-defense, for defense. Carrying concealed weapons did not fit within the state's constitutional allowance that a person could keep and bear arms for the purpose of defending himself and the state. The reason was that, for purposes of self-protection in moments of immediate danger, there can be no necessity for concealing the weapon. Hmm. Tellingly, in so concluding, the court explicitly rejected an argument that open carry and concealed carry are functionally interchangeable, and it also rejected the idea that as long as one mode of carry was permitted, it was irrelevant which was allowed and which was barred. Excuse me. Applying the same rationale, the Tennessee Supreme Court upheld that the state's concealed weapon ban, applying the same rationale, Tennessee, Democrat, slave owning, upheld that state's concealed weapon ban. See, again, Democrats. Finding that the right to bear arms in defense of themselves is coupled with the right to bear them in defense of the state, and that arms used in defense of the state must necessarily be borne openly, the court held that only the open carry of weapons was protected. Jeez. This decision was followed a few years later by a decision of the Georgia Supreme Court, again, another slave-owning Democrat state, which adhered to the same logic, concluded that the state's concealed weapon ban was permissible, but that a ban on open carry of guns and knives was too great an imposition on the Second Amendment. That's 1846. Nunn versus State. The court noted that the prescription of concealed carry does not deprive the citizen of his natural right of self-defense or of his constitutional right to keep and bear arms, but a prohibition against bearing arms openly is in conflict with the Constitution and void. The U.S. Supreme Court has referenced with approval the interpretation of the Second Amendment adopted by the Georgia Supreme Court. That's District of Columbia versus Heller, 554 U.S. 570 at 612, 2008, making the Georgia court's distinction between open and concealed carry all the more consequential. Likewise, the Louisiana Supreme Court, here we go again with another Democrat state and another slave state. The Louisiana Supreme Court explained the constitutional significance of open carry in its opinion in 1850, when it too held that a state statute could constitutionally ban concealed carry. The court specifically noted that the ban on concealed carry was only permissible because, quote, and here's a block quote, interfered with no man's right to carry arms in open view, which places men upon an equality. Hmm. I'm just saying a lot here, but you got to read the reasoning here. The reasoning is very important to get. The reasoning is very important to pay attention to. You see a trend here with the Democrat states? A lot of the Democrat scholars and professors will say Southern states. Well, yeah, they're Southern, but who cares about that? They're Democrat. They're Democrats. They're all it's only significant that they're Southern because it was in the South that the Democrats were the most powerful because of slavery, because the Democrats and slavery go together. It's easier to have slaves in the South because of the growing season is longer. That's all. They're Democrats. You got to pay attention to this, guys. Come on. Jeez. Okay. I, I'm going to go back to the top of that block quote again. It interfered with no man's rights to carry arms, to use its words, in full open view, which places men upon an equality. This is the right guaranteed by the Constitution of the United States, which is calculated to incite men to a manly and noble defense of themselves, if necessary, and of their country, without any tendency to secret advantages and unmanly assassinations. The North Carolina Supreme Court, that's the end of the quote. The North Carolina Supreme Court reached a, do you see a pattern here? There's another Democrat state, slaves, reached a similar conclusion when it upheld a conviction of a man for arming himself with dangerous and unusual weapons. State versus Hunley, 1843. This understanding that open carry is at the heart of the right to bear arms remained dominant in the wake of the 14th Amendment's adoption. Now, this is important here. This right here is the Republican gem right there. He's summarizing all these Democrat states, and there's what, half a dozen or so examples. This understanding that open carry is at the heart of the right to bear arms remained dominant in the wake of the 14th Amendment. So what this Republican judge on the Ninth Circuit is doing, writing for the majority of the court, he's saying in the Ninth Circuit here, January 2026 in Baird versus Bonta, page 22 in the middle. He's saying that even in the worst cases, the Democrat cases where they're regulating and restricting people from defending themselves, which is the Democrat impulse, and it's most acutely expressed on the plantation against black people, which is why they had slavery. That if the slaves had guns, would there have been slavery? You see, hello, hello. But this Republican judge is saying that what you get out of even the worst cases of restrictions before the 14th Amendment still has this Republican core that comes out because of our Republican form of government that was in the founding, that the Democrats, as horrible as they are here, they they are able to see the Republican gem here, that open carry is at the heart of the right to bear arms. So this is like an a fortiori thing. If they recognized it a fortiori, it is the historical tradition. because this is not the historical tradition. This is just a small set of something that was corrupt and like an ingrown toenail and perverse. But even in that situation, the Gollum situation, my precious, with the plantations, they still bore the image of God, as it were. Praise the Lord. These many courts were not just indulging consequentialist reasoning and finding that open carry was protected while concealed carry was not. They explicitly rejected the argument that the two kinds of carry were interchangeable. And they explicitly premised their conclusion on the ground that the right to carry arms in full open view is guaranteed by the Constitution of the United States. So even in this corrupted state, there's value there to be preserved, and there's nuggets there that we can build on. Praise the Lord. Our esteemed dissenting colleague disagrees. Faced with this extensive historical record, faced with this extensive historical support for the conclusion that open carry and concealed carry have never been treated as fungible under the Second Amendment, and the complete absence of any historical precedent for the opposite conclusion, the dissent basically musters one response: Bruin controls. How? Because Bruin said, history reveals a consensus that states could not ban public carry altogether. We wholeheartedly agree with the dissent that Bruin expressly forbids states from banning public carry altogether. Where we apparently disagree is that we do not read that statement as somehow meaning the opposite. Oh, wow. That was a nice dig right there. Where we apparently disagree is that we don't read that statement as somehow meaning its opposite. That so long as a state does not ban public carry altogether, it can do whatever else it wants without violating the Second Amendment. Respectfully, that is not only a basic logical error, but also obviously a wrong way to interpret language in Supreme Court opinions. If the Supreme Court said, quote, states cannot ban speech altogether, unquote, nobody would think it was also implicitly saying that as long as the state allows some speech, it necessarily can ban all other speech. Page 24 at the top. Wow. Instead, lower courts would analyze partial speech restrictions under the various rubrics the Supreme Court had provided for doing so. Okay. Yeah, I think that makes sense. We're skipping footnote 15. We're keeping going here. Here, in addition to directly addressing, let's see how far we got to go here. Okay, we're going to finish at page 27, which is Roman numeral V, and we'll be exactly halfway done at that point. Here, in addition to directly addressing, how about in addition to addressing directly, fixing your split infinitive again there, Van Dyke, the relatively easy and narrow circumstance where a state attempts to ban public carry altogether, easy answer, it can't. The court in Bruin also told us how to analyze other situations where the state imposes firearm restrictions short of a complete public carry ban. As our court has now repeatedly recognized, in that circumstance, we need to look to the historical tradition of firearm regulation. The dissent's attempt to short circuit or predetermine that historical analysis by asserting that Bruin has already directly decided the question presented in this case fails from the get-go. It clearly misreads one statement from Bruin and then uses that misreading to justify failing to do the historical analysis Bruin expressly prescribed. The Second Circuit committed a similar error by recently upholding New York's open carry ban. The Second Circuit's analysis relied on a similar misreading of Bruin, as well as approaching historical evidence at too high a level of generality. Like the dissent here, the court there claimed that Bruin treated open carry and concealed carry as fungible, quoting Bruin for the proposition that states, quote, could lawfully eliminate one kind of public carry, open carry or concealed carry, so long as they left open the other option, unquote. But again, that is transparently not what the Supreme Court said in Bruin. Now, this is a very important point here on the bottom of page 12. I want you to really focus on that, this error here in the Second Circuit. That is not what the Supreme Court said in Bruin. Indeed, is telling that the Second Circuit had to modify the court's language to support its holding. Page 25 at the top. Unaltered, the quotation from Bruin reads, quote, states could lawfully eliminate one kind of public carry, concealed carry, so long as they left open the option to carry openly. That's Bruin at page 59. The Second Circuit, you see how they misquoted Bruin, and these details do matter. The Second Circuit then cited a number of historical state laws and cases that upheld concealed carry bans, ignoring the fact that not a single one of its examples involved an open carry ban. The court described these laws and cases as evincing a strong historical tradition of regulating and often criminalizing, there we go again, criminalizing innocent conduct, one manner of public carry, so long as the government does not altogether prohibit public carry. The court's own examples demonstrate that the law, the court's own examples demonstrate the flaw in its logic, because those examples upheld concealed carry bans for reasons unique to concealed carry. They were not relevantly similar to New York's open carry ban. As described above, Chandler, one of Frey's examples, was concerned with, that's the Second Circuit case. Frey was the Second Circuit case. So this Chandler case was concerned with secret advantages and unmanly assassinations. That was one of the pre-Civil War cases committed upon unsuspecting persons. That's the Louisiana case from the 1840s. Likewise, Reed's rationale, that's the Alabama case that we referenced earlier, pre-Civil War Democrat. Reed's rationale was that it is only when carried openly that arms can be efficiently used for self-defense, for defense. I put the word self in there again. Interpreting these cases like the Second Circuit did as supporting a tradition of banning on generic safety grounds whatever type of carry the legislator wishes is precisely what Bruin's analogical approach forbids. Very important sentence there. That is exactly what the Supreme Court forbade. The approach that they take to Second Amendment forbade. Instead, a correct understanding of Bruin and of our historical tradition of firearm regulation leads inevitably to the conclusion we reach today. Page 26 at the top. California's clear failure to satisfy its Bruin to present evidence of a relevant historical tradition of firearm regulation is dispositive with respect to California's urban open carry ban. Once again, under Bruin, Second Amendment cases are straightforward when the challenged firearm regulation seeks to address general societal problems that have persisted since the founding. California's urban open carry ban indisputably seeks to address such problems, including, to quote California's briefing in this case, concerns about firearms creating a highly stressful and unsafe environment that has the high potential to create panic and chaos. Because California's regulations seek to address general societal problems that have persisted since the founding, there is no need to reach the Ninth Circuit's nuanced approach, the exception to Bruin's default rule, and the absence of a distinctly similar historical regulation addressing the problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. Likewise, under Bruin, the fact that earlier generations addressed the societal problem, but did so through materially different means, is probative evidence that a modern regulation is unconstitutional. I'm going to take a look at this footnote 16. This is worth reading. In similar fashion, the dissent's conclusion that the why of historical firearm regulations involved eliminating one manner of public carry in accordance with the cultural perception of what type of carry was more peaceable completely unmoors the analysis from history and tradition. That's very insightful. If the ultimate touchstone of the analysis is nothing historical or traditional, but instead our present notions of what counts as, quote, less peaceable, unquote, that should be a red flag that we are not applying Bruin's history and tradition approach. That's a very insightful point. Hmm. Because California's regulation seeks, hold on a sec. Because California's regulations seek to address, quote, general societal problems, unquote, that have persisted since the founding, there is no need to reach the Ninth Circuit's nuanced approach, the exception to Bruin's default rule, and the absence of a distinctly similar historical regulation addressing the problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. Likewise, under Bruin, the fact that earlier generations addressed the societal problem but did so through materially different means is probative evidence that a modern regulation is unconstitutional. There is no record of any law restricting open carry at the founding, let alone a distinctly similar historical regulation. And in the antebellum era, courts across the country were explicit, especially in the Democrat ones, were explicit in noting the unique constitutional protections granted to open carry. Thus, we conclude that California's de jure ban on open carry in counties with a population above 200,000 is inconsistent with the right to bear arms as applied to the states through the 14th Amendment, through the Republican 14th Amendment, page 27. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. Today is 19 February 2000, 26 years after Jesus. It's a Thursday. It's 12:55 p.m. in the Southland. It's raining. And I got to go to the church now to do some work, some admin work. We're going to move forward in the season of Lent, reflecting on the fact that we are dust, ashes to ashes, dust to dust. I got ashed last night at Ash Wednesday. And I want you to remember that we are all dust. It doesn't follow from that that protecting life does not matter, though. And that is what we're focusing on here today. Thanks for joining me on The Republican Professor. We'll see you later. God bless you guys.